Hi, everyone. My name is Adam Cohen. I'm an immigration attorney with Siskind Susser in Memphis, Tennessee, and want to talk to you today about U.S. immigration basics and certainly updates for international students as well. This is the first time I'm doing this sort of Zoom recording right now, so we'll see how it goes. Just to tell you a little bit about our firm, Siskind Susser PC is a U.S. immigration law firm. We practice exclusively U.S. immigration and really run the gamut of all of those services. And I specifically practice in the area of student and scholar immigration, healthcare immigration, and also general business. So I'm pleased for those of you who can tune in. I'm pleased to have you. So why don't we just start moving along on the basic information, the basic life cycle, let's say, of an international student. So it starts with the program start date, right? And then we see in the first 9 months of that life cycle, a student is eligible for on-campus employment. So we can see there's some limitations there. Now, this is really more of the general rule. There are certain exceptions as well. But we'll get into what we have time to get into today. So the rest of the program, the rest of that course of study is where the student is eligible for off-campus employment such as curricular practical training, severe economic hardship work authorization, pre-completion optional practical training, and even internship with an international organization. So there are those options as well. So I think most people would be familiar with the CPT training, and we'll talk a little bit more about that during that time frame. And then we have our graduation or defense date. And that is when the student becomes eligible to apply for post-completion OPT. Again, this is a general rule. There are certain possibilities that post-completion OPT might open up earlier than that. It just really depends on completion of coursework and things of that sort. But the student becomes eligible to apply for post-completion up to 90 days prior to, but no later than 60 days after the program end date, and also within 30 days of the DSO, the designated school official, the individual who monitors the SEVIS account for the student, 30 days of the DSO's recommendation in SEVIS. So you can see that there's that date range and there's also the recommendation and the range of 30 days after that recommendation in SEVIS as well that matter. Now, it's obviously you can apply for OPT during that grace period, that 60-day grace period, but it is much, much better to get an early jump on this. A lot of students file I-765s for their OPT. They do it by themselves. And it can happen where there's a missing signature, a missing filing fee, or it's not sent to the right address, and that can thereby cause a rejection of the OPT. And by the time they go and they learn of the rejection, they go to refile, they can find that they're outside of that date range, right? They're outside of that period. So it's very important to get a jump on that. I have seen students lose their ability to apply for OPT and STEM OPT as a result of rejected filings that then trigger late subsequent filings. Also, the 30 days of the DSO's recommendation, that's not necessarily going to be seen on the student's I-20 form that they have. So it's important to be talking to your school, talk to your DSO to find out when they have recommended that OPT in the SEVIS system. Okay, so that's my little public service advisory there. Now we move on to the 12-month OPT after that period, right? And that is that 12-month training period, standard for really almost all courses of study. And then finally, the last part where it talks about next steps. Well, those can really just depend on the individual circumstances. Some will return to school. Maybe they're an F1 student for a bachelor's degree and they want to return and they want to do that master's degree. So they're returning to school. Some of them will do the standard post-completion OPT. Others will move right into that course of study. Some who have degrees in science, technology, engineering, or mathematics, they might be eligible for a 24-month STEM extension, which we will talk about as well. And others will return to their home country, or still others will do a change of status within the US, or an adjustment of status even to get a green card. So we will talk a little bit more about that as well. I'll just, given time considerations, and I don't think you all want me just to be talking at you for a good hour. I'm going to try to keep this shorter than that. And we won't get into all of the other statuses that an F1 can change into. We're going to mostly just be talking about changes into H-1B. But we're going to go through a lot of this life cycle that I've been discussing. But first, what's new in immigration these days? So I have to use Moana because my children love Moana. And this is just like the chicken in Moana. This is how I feel on a Friday afternoon when I get brand new immigration updates. It sometimes feels like shoveling sand in just an atmosphere of ever-changing policies. So let's talk a little bit about that. What's new? A lot. Okay, so let's start with just COVID-19 in general and this global pandemic, which has brought basically a slew of information. Let's go into that a little bit. A lot of that does affect students, either generally or specifically. So, and many of you may not be aware of all of these changes too. So let's talk about them a little bit. So the first part is just the suspension of most in-person services at U.S. embassies and USCIS field offices. The embassies, that's a big one, right? Because our initial students who want to come in, or maybe individuals who need to renew their F1 visa from abroad, they're having trouble doing that. They're having trouble getting any type of appointment at a local embassy. Now, I think with the USCIS field offices, those are starting to reopen. I think as of yesterday, but a lot of people who had biometrics appointments, their fingerprints appointments, they're waiting for those to be rescheduled. Who does that impact? The biometrics? Well, that's for people who are going to be changing status within the US to F1, for example, or even individuals who have gone from their F1 to H1B and they want to get their spouse derivative H4 status, but that requires biometrics too. So there's just been delays across the board there. There's also been the US and Canada and the US and Mexico, the land borders. There were joint restrictions on travel, except for essential workers. And this one's a good one, really, it turns out, because at least in Canada, probably Mexico as well, but in Canada, the travel across the land border for essential workers does include those who are traveling to attend an educational institution. So that really shouldn't be a restriction to students as much. Now, we're talking about travel restrictions. We certainly have to talk about the president's travel bans and presidential proclamations and things of that sort. So much has happened these days that people forget that there's a variety of pre-existing travel bans as well, which I don't really have time to get into all of those, but we are going to put a resource in at the very back that is our firm's travel ban advisor. And that's very helpful because if you go through the questions, you can see whether there's any travel ban in place for you, or if you are from universities, if you're DSOs, welcome, and you can use this resource as well for your students that you're advising. So it'll go into the pre-existing travel bans, and then it will also go into the 14-day, I guess you could say, quarantine travel bans that came about just because of the COVID-19 pandemic, and really just out of this interest of stemming the tide of the pandemic, restricting the spread, so to speak. And those are in place. It started in China, and then Iran, and then various European nations and UK, as well as Ireland. And then finally, lastly, Brazil. That was the last one. Then you see here on the PowerPoint slide, you see IV. That is the immigrant visa proclamation, basically April 22nd, 2020 proclamation from the president that is limiting the entry of immigrants. So immigrant visas. There was a lot of concern from people who were thinking that this impacted green card processing in the US. It doesn't. And it doesn't really have much impact on students, F1s, J1s, M1s. because they're in the early part of their career and they're not really oftentimes doing a green card. And if they are, say, like a marriage-based green card for an F1, that's happening as an adjustment of status, a stateside green card processing within the US. So it's not impacted from the immigrant visa ban. However, I have seen it, it could be the situation. I have someone who is in an F1 who has a employment-based green card process and is trying to bring family over now from abroad. So as on an immigrant visa, and so it can impact family members who are traveling, who are trying to come into the U.S. As well. So that's a small impact for students, for some students. And then finally, there was this most recent one that occurred on May 29th, which was this travel ban against F and J, individuals, visa holders, you could say, from China. Okay, and this has to do primarily with researchers who, and I want to make sure I get the wording right here. It is researchers who are, they're doing research that's related to an entity that supports the People's Republic of China's military civil fusion strategy. Okay, and this is the attempt by the People's Republic of China, is what they're describing as their attempt to acquire foreign technology to advance military capability. Many of you may have seen some of the stories there. There are some particularly egregious stories and a lot of government investigations related to Chinese acquisition of technology. So that's part of what prompts this this type of ban. And it's looking at not just a bona fide acquisition of foreign technology. It's talking about abuse, by having had access to this type of research. Okay, so they're looking to ban F&Js who have that research that's related to entities that support this strategy, this military civil fusion strategy. Okay, it also, I'll just say, does not pertain to F1, Chinese F1 undergrads. Okay, so that's one particular carve out. There's a few other carve outs that are in there as well. And this is banning the entry of these individuals. And they have talked about maybe potentially revoking the visas of these individuals if they are inside the US. So that's an additional, perhaps additional complication to this. So it's definitely something that we will continue to be monitoring. So we talked about entry, right? We're talking about barring entry into the US and restricting entry into the US by virtues of closures or travel bans. Now, what about those individuals who are currently students and they are doing remote learning, online learning? They are perhaps the school doesn't offer remote learning. What is the situation for them? So the Student and Exchange Visitor Program, which is a component of Department of Homeland Security, they're the ones that manage the schools and manage these the Fs and Ms and J statuses, right? At least the CVIS system as well that tracks those types of statuses. They actually have offered a lot of guidance in this area, guidance that we have not seen from a lot of the other immigration-related agencies. And they're providing a lot of flexibility. Basically what it starts with is schools, tell us what procedural adaptations you are needing to make because of COVID-19. You can report it to us directly or you can use a template to report it, but tell us what's going on and tell us within 10 business days of the change. And that's primarily what they want to know. And they want to see that even despite that, to the extent the student is able, they are making normal progress to their degree. So there's been some, they're allowing for remote learning, right? Because typically it's been a problem to have more than one online class per semester. But they are making allowances as long as it's in the procedural adaptations. They're making allowances for remote learning. They're making allowances where remote learning is not possible even. as long as it's reported in the adaptations. So maybe there's some some students who are not attending classes right now, but they are still considered to be in active status through this emergency. So some very interesting and helpful guidance that have come out. Some other things are provisions that are allowing remote on-campus work in certain situations, that are allowing remote work for OPT and STEM OPT students, that are allowing OPT and STEM OPT students who are working fewer than 20 hours to still be considered in active OPT and STEM OPT employment. That wasn't the case before. If you're less than 20 hours, you're starting to accrue unemployment time generally. But through this emergency, there are certain flexibilities that are being applied here. One can also potentially do CPT, curricular practical training from abroad, in certain circumstances. And as I was mentioning before, it usually takes about a full academic year before one becomes eligible for CPT or for post-completion, or I should say pre-completion OPT. But the flexibility here is that SEVP is also allowing students to accrue that 1 year, whether they're inside or they're outside the US, as long as they're active students and the procedural adaptations are in place. So I'm trying to bullet out for you all some of the flexibilities that have been applied, but needless to say, there is some flexibility provided that the procedural adaptations have been noted to SEVP by the school. So it's something that students can certainly check on and just talk to the school about these adaptations and if they've been submitted to SEVP. But I'm sure most of the schools, if not all, are taking care of all of that. So that's COVID-19 and what those, obviously there's a ton of evolving guidance there, and there's so much more to all of the policies that have come out for people who are in other statuses, but trying to keep it tailored to our F1 students as much as possible. So greater scrutiny on the degree and training relationship. This is something that has come out of 2019 guidance from SEVP. And they're just trying to get DSOs to show greater scrutiny in the difference, or the relationship, I should say, between the course of study and the training opportunity on OPT. A lot more scrutiny, sometimes research, sometimes additional questions for employers and employees. It's always been, it feels like it's above and beyond what the regulations are requiring. But it's important for students to be aware of that and to have their employers take a more active role and students take a more active role in helping to supply the DSO with any documentation that they need to show that relationship. I would also recommend to students that they really consider very carefully whether they want to report this relationship information into their student portal. And maybe would want to seek out some guidance before they do that. STEM OPT site visits have been contemplated since the 24-month rule took place in 2016, but they've actually started over the last year. So it's important to be aware of that. And really just my note of caution to students is to understand that this I-983 training plan that is part and parcel of STEM OPT that has to be done should be done in conjunction with the employer. It shouldn't be a unilateral move from the student to define their objectives and who their supervisor is and how they'll be evaluated and things of that sort. Because if a site visit were to occur, the I-983 really needs to be in order. So it's really trying to take getting the employer to take a more active role as well in the development of the 983 and being aware of all the obligations the student has with reporting and the employer has to report related to material changes and other things of that sort. So that could be a presentation in and of itself. A lot of these categories could, but I'm just trying to flag some important issues for students and schools and employers to be aware of. The H-1B pre-registration rule, we will talk about that soon. Now, the most recent thing that came that just kind of made me throw my hands up in the air because there's just so much guidance that's ever evolving, is this proposal now that's been on the wish list for Department of Homeland Security for a little while. It's a proposal to replace the duration of status that all you students have on your I-94s. So, you are in proper status through the authorized period of your course of study, as noted on your I-20, to replace that designation with an actual date certain. This is concerning because you think about having to file extensions with USCIS every single time. Would this be year by year? Would it be when you are changing from one course to another, or you have to extend your program somehow because you're not graduating on time? There could be a lot of costs, there could be a lot of delays. And what happens while that application is pending? If it's done on a 539 form, there's no premium processing. That's when somebody changes to F1, they use an I-539 to do that. And there's no premium processing. And if you try to expedite it, you have to really show some very like humanitarian reasons or something pretty important, such as that. So delays in filing fees and what happens to the student while the 539, if that's what they use, is pending. There's a lot of very difficult considerations here. So we're just gonna have to monitor what's happened. This proposal has gone to the Office of Management and Budget. We don't actually have the text for it yet. So we will see when it comes out. If it comes out as a proposed rule, we'll have the opportunity to comment on it. Everyone will. And I'm sure a lot of schools will want to weigh in before any type of regulation would be finalized. But just something that we'll keep our eyes on. So I know I've done a lot on the updates, and we'll see. I'm going to try to keep myself within maybe about 40 minutes altogether. And so I'm going to try to run through some of these other, just going through some of the life cycle material that I talked about in the context of these updates. So we talked a little bit about curricular practical training. And this is the most common type of training that occurs during the F1's course of study. And, it's probably because curricular practical training doesn't typically draw down optional practical training time, that standard post-completion we talked about of 12 months, doesn't really draw it down unless there's more than 365 days of full-time CPT. So that's different from something like a pre-completion OPT that actually does draw down the OPT. But basically the eligibility requirements are you to be enrolled full-time in a degree program for 2 academic semesters, like 9 months, before you seek the recommendation of the DSO for CPT. There are things called, there is something called immediate CPT or day 1 CPT, which is more disfavored by USCIS. It's certainly possible in certain circumstances, but I won't go too much into that right now. Otherwise, it's typically a 1 year, 1 academic year requirement before one is eligible. They have to be making normal progress toward the completion of the degree, and the activity has to be directly related to the field of study, and also integral to the course of study too. Typically, you'll see, there isn't any type of filing with USCIS. It's really just approaching the DSO and asking for a recommendation, an endorsement for CPT on the I-20. And that is going to be the basis of being able to be in valid CPT and to be verified by the employer, employment verification, like an I-9 form. So CPT, oftentimes there will be a CPT course, like an internship course in which the student will enroll. And typically there's also a cooperative agreement between the school and the employer for that type of training opportunity. As I noted, more than 365 days of CPT will end eligibility for OPT. That's full-time CPT. Full-time CPT is more than 20 hours per week. Part-time CPT doesn't have any effect on OPT and has a maximum of 20 hours of work per week. Then we go into optional practical training. So You don't see pre-completion as much because it draws down OPT, as I mentioned. We have our post-completion OPT. We have our STEM 24-month OPT, where the student is eligible, which we'll talk about. And then there's also something called OPT cap gap extension for those who are applying for a cap subject H-1B, which we will also address. STEM OPT, in 2016, it was expanded from 17 months to 24 months, and it brought a lot of other very nice benefits. The ability to get up to 2 24-month extensions. Okay, now this is one 24-month extension on top of a 12-month post-completion. So, bachelor's degree you had in engineering, 12-month OPT, and then 24 months of STEM OPT. Then you go back to school for your master's degree in engineering, and then you get 12-month OPT, and then you get another 24 months of STEM OPT. That's kind of how that works, okay? There's also this interesting ability to almost recapture, I guess, unused STEM time from a prior STEM degree. So let's say, using that same example, bachelor's degree in engineering, and the individual just kind of goes right on, they don't get STEM OPT, they go right on to their master's degree, only it's a master's degree, it's a master's of business administration, it's an MBA, so it's not a STEM degree. So then that person does their 12 months of post-completion after their MBA is complete, and then may be able to get the 24-month STEM extension using the prior STEM degree. So there's it's definitely something that needs to be evaluated a little bit more, and there's certain restrictions there, but it could be a possibility to be able to have that recaptured. Allowable unemployment periods were increased too. So standard post-completion OPT, one can have unemployment time of no more than 90 days, and then there's an additional 60 days for STEM OPT. And this clock runs, it runs in CVIS. So it's very important to understand that that clock is running. And while we're on the subject, that is something that there have been advocacy efforts to get that clock suspended during this pandemic, but that has not yet occurred. So it's important to understand too that SEVP can't make all those decisions on its own. Some of them have to be done in collaboration with USCIS, but that collaboration has not, it hasn't yielded that type of guidance on the unemployment side. Now, with all these great benefits, there's also certain restrictions to kind of rein in the STEM program. There is a formal I-983 training plan, which I alluded to, that is between the employer and student, signed by both, that goes over the relationship between the training opportunity and the course of study, what the individual, the student, will learn, the objectives of the internship, how that individual will be supervised. So there are certain U.S. protections, U.S. worker protections, such as the salary for the STEM OPT worker has to be commensurate, similar to the salary of the U.S. worker, the similarly situated U.S. worker. And there's other types of employer attestations as well. We talked about the site visits, and all I'll say about self-employment and third-party placement is if one of these situations apply, it's good to talk to counsel just to see, there are certain carve-outs where self-employment may be possible. Third-party placement really depends on who's supervising the STEM worker, so if they're being placed off-site, if it's a staffing company and they're being placed off-site, who is supervising that student? And making sure that they are meeting those objectives put in the I-983 training plan. So just some things to think about there. I will note as an aside, there is some litigation that is ongoing related to the viability of not just STEM OPT, but OPT itself. So there's not really much more to talk about because, again, it's another long, detailed type of subject, but it's important to be aware of that. It's also important to be aware that with respect to that April 22nd presidential proclamation I was talking about, it bars immigrant visas, but there's also been some consideration that it might be extended to OPT, to F1s. So it's just something else that we'll have to stay tuned to. So what about life after the F1? These are variety statuses. I'm going to leave this for you all to see here. we can't get into all these statuses right now. We're going to talk about H-1B, which is by far the most common route for individuals who aren't returning home and aren't going back as an F1 to a new course of study, like a higher level, bachelor's to master's, for example. H-1B is by far the route that is chosen by international students. So that's why it's going to receive our focus. Okay, so H-1B status. H-1B status is a professional work status. It's probably the reason why it's the most common of those professional work status. That's the reason why most international students go in that direction. It requires at least a bachelor's degree in a specific specialty. The position must. And of course, the employee, the intended employee, must possess the qualifications that are required by the employer, okay? There also is a prevailing wage requirement. There are certain wage requirements and restrictions. And it is, of course, employer-sponsored. And there is a 6-year limit to the H-1B unless the student meets certain benchmarks in a green card process that allows for extensions beyond those 6 years. Now, the H-1B process, for a lot of students who are not going into academia, they're going into what they say, industry H-1Bs. They have to deal with a very competitive H-1B process. There are 65,000 slots that are available every fiscal year for H-1Bs, and then an additional 20,000 slots for those employees, those applicants, beneficiaries, who have at least a U.S. master's degree in the U.S., right? So it's a U.S. master's degree, not just any master's degree like from abroad, U.S. master's degree. So that's 85,000 slots, which sounds like a lot, but then you have to put it next to demand, which has actually increased, and we'll talk about that. So that is the numerical caps. Demand always outstrips supply. For the last several years it has, so the H-1B process goes to a lottery. Now, there is a way around the lottery, and just generally, it's having an employer, someone who's going into academia, for example. They are going to be working at a university, they're going to be working at a nonprofit affiliated with the university, or they're going to be working at a nonprofit or government research organization, for example. And that may be a way, whether they're employed by that entity or they're working at that entity for a majority of the time, that is the way around the H-1B cap. And there's other creative arrangements with respect to cap exemption to make it work, but that's really outside the scope of this presentation. So let's get back to talking about the numerical caps, and we're going to put it now within the context of the H-1B pre-registration rule that came out. Now, 2 years ago, they started reversing the way they run the caps in the lottery. Okay, so it started with, it used to be that they would run the master's cap first. And after they took 20,000 names out of that pool, they would then run the bachelor's cap. Now they run the bachelor's cap first and then the master's cap. So what it means is by the time they run the bachelor's cap, there are more U.S. master's workers in that bachelor's cap, general cap, than there would have been otherwise. Okay, so it means that the H-1B process is becoming more skewed, even more than it was before, toward those with U.S. master's degrees. So that's very important to keep in mind. The other thing that changed is this past season, was the first time they rolled out an electronic registration system, pre-registration, where for $10 filing fee and a bare bones, basically bare bones online form, one could be entered into the lottery, the H-1B lottery. So that created, that ended up making more people apply than there has in prior years. So I think it was closer to about 270 or 280,000 applicants this year versus about, in the past few years, it's been like 190,000, 200,000, somewhere in that area. So it's hard to predict a trend just from that one season, but it just makes it a more competitive process, especially for those who do not have a U.S. master's degree or above. Also the climate, that's just sort of the bare bones registration. After that, there's the substantive filing that's going to be, that's the period that's happening now, the very beginning of April all the way to about June 30th, I believe. The substantive filing. And those substantive filings are subject to more government requests for evidence and more challenges than ever before. One of the big ones is the specialty occupation side, right? That the position requires at least a bachelor's degree or higher in a specific specialty. So what if the position requires a bachelor's degree, but a variety of specialties might be workable? There's certain challenges that had not come before in the H-1B context. So it's just important to understand, and that's the reason why it's good to have backup plans and other alternatives and possibilities. Which, by the way, I forgot to mention, but in my prior slide, I was talking about green card processes. Well, you saw it mentioned green card processes anyway. For some people, that could make sense. Like if they have a standard post-completion OPT at 12 months, and then they have an additional STEM extension for 24 months. For individuals who are not, not from countries that typically experience visa backlogs like India or China, for example, for other individuals, they may be able to get a green card process done during their OPT, which then just gives them a good backup option in case they're not selected in the H-1B. So something to think about. A few words about CAP-GAP. I think this might be my last slide apart from some resources. So the CAP-GAP extension, is for these individuals, who are graduating in May or June, but their CAP subject H-1B, those don't begin until October 1st. They always begin, no earlier than October 1st. So how does one bridge the gap? And the way to bridge that gap is by filing, typically filing the H-1B while the individual is still in F1 OPT. And so they're bridging the gap in their work authorization. Now, as long as they timely file before the end of their F1 grace period, the student can remain in the US while the H-1B is adjudicated, but they need to actually be in OPT to get the benefits of the CAP-GAP work authorization extension, and actually be in OPT when that H-1B is filed. That's what I need to say. If the H-1B is denied, withdrawn, revoked, the student will have 60-day grace period. Now, I used to say there was a grace period if the person was not selected, but this has all changed with this bifurcation of registration on one hand and then substantive filing on the other hand for H-1Bs. So you have to get selected and you have to file the substantive H-1B before you receive CAP-GAP, the CAP-GAP extension. So it's not a question of selection anymore. You have to be fortunate enough to get selected in the CAP. And then you file before the end of your OPT and you get CAP-GAP extension. That's kind of what's changed here. There is some provision about being able to travel during the CAP-GAP. And I'll just say also the work authorization is only valid until September 30th. Okay, so a lot of times, especially with the challenges that we've seen with H-1Bs, the H-1B might still be pending beyond September 30th, but the CAP-GAP authorization is only valid until September 30th. So sometimes the F1 student has to get taken off the payroll while that H-1B is still pending. They can stay in the US as long as their H-1B was timely filed while they were still in F1 status or in the F1 grace period. They can remain, but they can't work after September 30th. So just something important to understand. These are some resources here that you all can take a look at. The Siskind Susser Travel Ban Advisory that was created by our own Greg Siskind that goes through all of those different travel bans. We also have a coronavirus immigration blog to monitor updates. And there was an article about that we had done about the STEM OPT site visits a little while ago. There's other resources as well, but these are some that we believe will be very helpful. So I want to thank you all today, and this was good. It's good to just be able to talk through some of these updates, and I hope you all enjoyed it. Take care.